Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources. SEER is a member organization whose mission is to foster the success of a diverse community of environmental, energy, and resources lawyers, advisors, law students, and decision makers, and provide a premier forum for the exchange of ideas and information.
Clean Air Act Basics, Episode 3, the Montreal Protocol and Title VI, a success story. Today's podcast was inspired by a discussion I had this semester with a couple of students. They were taking an environmental law class, and they were demoralized by the feeling that environmental issues were too daunting, that there was nothing we could do, that we were doomed. And I get it. Environmental issues can be frustrating because they're hard. And in the podcast today, my goal is to highlight an environmental success story, a legal and social and industrial response to a complex international issue. You may have heard about the hole in the ozone layer. The issue we're focusing on is the depletion of stratospheric ozone layer and the worldwide response to that problem. The Montreal Protocol is a 1987 international agreement that set a mandatory timetable to phase out ozone-depleting substances. And the interesting thing about it is, for the most part, it worked. For the most part, the thinning of the ozone layer has been held in check, and it's improving. My guest today is David Doniger. Mr. Doniger is currently the Senior Strategic Director of the Climate and Clean Energy Program at the Natural Resources Defense Council. He was also instrumental both in the development of the Montreal Protocol and in the development of Title VI of the Clean Air Act, which implemented the Montreal Protocol in the United States. My name is Matt Oakes. This podcast is part of a short series called Clean Air Act Basics that attempts to explain essential parts of the Clean Air Act in terms that someone new to this area of law can understand. This is the third podcast in the series. The first one discusses the historic origin of the Clean Air Act. The second discusses rules that manage the types of air pollution that cross state lines. I also teach a Clean Air Act and environmental law course at both the University of Maryland and at Georgetown University. And I'm senior counsel for the United States Department of Justice, where I typically work on Clean Air Act issues. I host this podcast in my personal capacity. Nothing I say here expresses the views of the United States. All right. So as I mentioned, today we're going to discuss the Montreal Protocol and Title VI of the Clean Air Act. Title VI, again, is the U.S. law that seeks to control the emission of ozone-depleting substances. But before we jump into that, a little background to frame the issue. First, what does the ozone layer do? The ozone layer absorbs a portion of the radiation from the sun. It prevents that radiation from reaching the planet's surface. In particular, ozone absorbs a type of ultraviolet light called UVB, and UVB has a number of harmful effects. It causes skin cancers, it causes cataracts, it can harm some crops. And without the ozone layer, the Earth would essentially be sterilized by ultraviolet radiation. The next question, what is ozone? Ozone is a gas. It's comprised of 3 oxygen atoms. Ozone can be both natural and it can be man-made. And it's found both high in the atmosphere, the stratosphere, and lower in the atmosphere, the troposphere. Ozone is also highly reactive, almost unstable. It means it can be easily broken down by certain gases. So when ozone is exposed, the gases containing the halogens, chlorine, and bromine, it breaks down. It becomes something that isn't ozone. And the next thing that you should understand is the difference between stratospheric ozone and ground level ozone. The stratospheric ozone layer occurs between 6 and 30 miles above the Earth. And this is the layer that we just talked about that blocks harmful radiation from reaching the Earth's surface. Ground level ozone is the same substance, the same 3 combined oxygen atoms, but it's on the ground. It's the air we breathe. It's in the troposphere. And it's formed typically by the interaction of volatile organic compounds and nitrogen oxides. For example, car emissions, paint emissions, gas pumps, etc. They're all prerequisites to the formation of ground level ozone. This contributes to the development of smog, and it makes it hard to breathe and causes a whole host of irritations. And so I guess the summary is stratospheric ozone layer is really good and necessary to protect life as we know it. And ground level ozone could be really bad and causes smog and asthma and other complications. And so a brief history of our realization that the ozone layer was thinning. I'll start back in 1985, even though our history with this issue goes even further back than that. But in 1985, the extreme depletion of the ozone layer was discovered by scientists from the British Antarctic Survey. And they called this the Antarctic ozone hole. It soon became a worldwide issue. It was in headlines, and it was clear that this thinning was caused by man-made chemicals called chlorofluorocarbons. And so through the 1970s and the 1980s, the international community became increasingly concerned that ozone-depleting substances would harm the ozone layer. In 1985, the Vienna Convention for the Protection of the Ozone Layer formalized international cooperation on this issue. And this cooperation subsequently resulted in signing the Montreal Protocol on substances that deplete the ozone layer, and that was signed in 1987. And here I'm going to turn it over to David Doniger. David, how were you drawn into ozone issues? Can you tell me a little of your personal history?
Sure. The ozone layer story began actually in 1974 with the publication in Nature of a paper by two scientists, Sherry Rowland and Mario Molina, who later shared the Nobel Prize in Chemistry for what they found out. And they were investigating what happened to these chemicals, these CFCs, that did not break down readily. They were very stable inside machinery, like air conditioners, but also once they get out into the atmosphere. And they wondered, Rowland and Molina wondered, where did they go? And they ended up concluding that they went to the stratosphere. They wafted up into the atmosphere, higher and higher into the atmosphere. And when they reached the stratosphere, something sort of diabolical could happen. Now, as you mentioned, the ozone layer in the stratosphere screens out ultraviolet radiation, which is dangerous to life here on the surface. In fact, if there weren't an ozone layer, we probably never would have evolved life on land because of that radiation. But the CFCs, when they get up there, the only thing that can break them apart is the very ultraviolet radiation we were just talking about. So it splits the CFCs apart, and the chlorine in the CFCs, or the bromine in some other chemicals, then reacts catalytically with the ozone, and it turns these O3s back into O2s, which don't do any good for screening out ultraviolet radiation. And at the end of each of those little reactions, the chlorine or the bromine atom pops out again, ready to do it again. So in the normal state, ozone is being created and destroyed constantly, but at a constant rate. So you have a constant amount of ozone in the stratosphere. And when you added these chemicals in, you added an extra minus, and the layer of ozone was getting depleted. Now, in the 70s, that caused an instantaneous public reaction. And the principal use of these chemicals then was as aerosol spray repellents in underarm deodorants and kitchen products and so on. And the American public sort of collectively said, yuck, I don't really want to do this. Use these products for the danger of increasing skin cancer risks for everybody. And the sales fell off really dramatically in the mid-70s. The government kind of came in and cleaned this up under several old laws. The Food and Drug Law deals with aerosols that were used for food, drug, and cosmetic purposes. The pesticide law dealt with aerosols used to propel bug sprays, and so on. And in 1977, Congress amended the Clean Air Act and added a single provision, Section 157, that authorized EPA to regulate chemicals that were endangering public health and welfare by endangering ozone in the stratosphere. So EPA did clean up most of the aerosols. And the government began to explore with other countries whether we could reach an agreement to do the same around the world. That kind of that discussion started at the end of the of the Carter administration, carried over into the Reagan administration, and kind of petered out. The Europeans at that time were not the enlightened environmentalists they are now, and Japanese were in the same boat. And the US, Europe, and Japan at the time accounted for almost all the production of these chemicals. So the 1985 Vienna Convention that you mentioned was kind of a booby prize, an agreement to continue to study things and meet again in several years to try once again to make an agreement on control measures. Well, in the meantime, back in the US, I joined NRDC in 1978. And at the end of the 80s, just before the change from Carter to Reagan, the EPA issued a scientific finding that turned out to be really crucial. They said, even though we've got rid of the aerosols, the other uses of these chemicals in air conditioning and refrigeration, which leak, in solvent cleaning of electronic equipment, which leaks, in various other uses, those uses were growing, and those uses still posed a danger to ozone in the stratosphere, and therefore a danger to human health and welfare down here on Earth. Well, when the Reagan administration came in, the EPA was headed by a bunch of people who, it could be charitably said, didn't believe in the mission. And they didn't do anything about this. And they self-destructed for other reasons in the first 3 years. And President Reagan nominated William Ruckelshaus, who was the first administrator, to come back in and clean the place up. At that point, NRDC decided it was time to take legal action on the basis of the finding that had been made at the end of the Carter administration. We had been afraid in the first couple of years of Reagan that if we brought a lawsuit, the government would respond by revoking the finding. We trusted that Ruckelshaus wouldn't do that. We were right. We brought a lawsuit. We ended up with a settlement agreement that provided for a 2-year period of studies and international and domestic conferences, which were incredibly successful. The studies were it was produced about a 2,000-page analysis of the science and the economics, which is the model of how you do these kind of things these days. It showed that the chemicals were on the rebound because the sectors that I described were growing, and that pretty soon we would be having more total production of these chemicals than we did when the aerosols were the big issue. And it was also at that time, as you mentioned, that the British Antarctic Survey scientists discovered not just this generalized threat to the ozone layer everywhere over our heads, but this particularly severe depletion occurring over Antarctica. And it was confirmed a year or two later by NASA running basically a version of the U-2 spy plane through the ozone hole and capturing the chemistry so that they could really nail that it was coming from the CFCs. And they discovered a very special mechanism that happens in the super cold of the stratosphere over the South Pole. But it confirmed that we had a very serious problem there and not quite as dramatic, but a serious problem evolving all over the world. And the EPA risk assessment established that there would be millions and millions of skin cancer deaths and tens of millions of skin cancer cases if you looked out over the course of the next 50 to 100 years if we didn't curb these chemicals. One other thing we learned was they live a long time in the atmosphere. In that respect, they're like the greenhouse gases. In fact, they are greenhouse gases. I'll come back to that. But they live a long time in the atmosphere, which means if you want to get rid of them, you think of it as the atmosphere is a big bathtub, and the drain is almost plugged up, and the taps are running fast, and the bathtub gets more and more full. The only way that you can get rid of these chemicals is to turn off the taps and wait for the drain to slowly drain these chemicals away.
Follow up on something you mentioned, that there was a lot of publicity when, I'm younger than you, but I remember the headlines, and I remember when they sent the plane and measured the thinning of the ozone layer and all of the headlines. Is it right, or is it just my kind of accentuated memory that this was a really big deal at the time? And it seemed like the things that people were highlighting were the hairspray cans and air conditioners. At least, that's what I remember when I was young. Is that true? And
yes,
how
that's
much
right.
press was he getting?
Well, it got an enormous amount of press in the 70s and again in the 80s. There was a lull in between, but you got these pretty clear and stark stories backed up by computer graphic maps from satellites and so on. And people just said, what are we doing this for? For these chemicals? For this? I mean, to the extent that the aerosol thing really was a public reaction and a public consumer-led change of taste, so to speak, in the kinds of products people bought. For air conditioners and for electronic solvent cleaning and fire protection and other things that these chemicals did, public really doesn't see those chemicals or isn't that aware of them. But the companies in this period of the 80s went through a change of heart and change of position. I would characterize the industry in the late 70s, early 80s as organizing itself like every other trade association in Washington, which is going to dispute the facts, claim the sky, not the sky is falling, the economic sky is falling, dispute that the real sky is falling. For example, the Alliance for Responsible CFC Policy, as they were called, ginned up a grassroots campaign by every HVAC, heating and air conditioning company, telling them if EPA does something here, it will be the end of your business, the end of your livelihood. You will be the one who doesn't have the chemicals. And there are no alternatives, and tell the president, tell the congressman to knock it off. That actually, that wave of protest, of grass, AstroTurf, industry-generated protest was pretty effective at the beginning of the 80s. But we kept pushing them with this litigation. In fact, there was a cabinet meeting, which I heard about, where Edwin Meese, who was the attorney general, this is in the mid-80s, he said, we really better back the idea of this treaty, because if we don't have a treaty that imposes restrictions on the Europeans and the Japanese, then the Americans companies will get stuck with regulation when the NRDC wins its lawsuit, and we won't have a level playing field. So so we ended up with the Reagan cabinet, with one or two interesting exceptions, and the president backing the effort to get a global agreement and to manage the, if you call it, the risk for the companies that the Clean Air Act litigation from the NRDC would result in them being uniquely regulated. At the same time, we were having a lot of conversations with the industry. EPA set up these very productive meetings, and the industry came in. There's one that really sticks in my mind where somebody from DuPont, which was at the time the major manufacturer of these chemicals, came in and said, there really are no alternatives, and we want to prove it to you. And then they went through a list of all the other chemicals they had looked at and their properties and so on. And for each of the major CFCs, they identified a bunch of alternatives, and so these would work. Technically, they would do the air conditioning or whatever else was required of them, but they're more expensive, so they're not feasible. And I said, well, you're telling me that what's holding them back is that the existing chemicals are too cheap. What if we tried on a gradual basis to reduce the supply of the existing chemicals, to phase them out, and that would make the market for the new chemicals? Now, to this day, I don't know whether I really put that idea in their heads or whether they were maneuvering me to put that idea in my head. But the industry changed its position. And in a conference in 1986, I proposed a 10-year phase out of these chemicals. And the industry representatives announced that they could tolerate limits on their production, limits on growth, they put it. But really, they were signaling that they could live with some limits on the total production. And from that, the US government took into the negotiations leading up to the 1987 Montreal Protocol a position that we should 95% eliminate these chemicals over 10 years, a 95% phase out. It was really a dramatic proposal coming from the Reagan administration, and one that very, very closely followed what we were proposing as environmental NGOs.
In the mid-1980s, had we ever seen a phase out of a chemical like the one that you had proposed for CFCs?
Well, the closest I can think of is the phase out of lead from gasoline. It didn't happen overnight. It happened in steps. And, you know, from a public health point of view, lead was dangerous. It was hurting kids every day, and it would have been better to eliminate it overnight. But the environmental agency and the environmental community went along with the idea that we could do this in steps and phase it out. And the same concept, I was applying the same concept to CFCs, that if we insisted on banning them immediately, the disruption or the risk of disruption would, you know, constantly frustrate. We wouldn't be able to get it through, because people would say, well, what are we going to use for air conditioning next year? And a 10-year phase out would give time for the companies that make the chemicals and use the chemicals to introduce the new ones and to modify their products so that they could use the new ones. We did not insist on, you know, some sort of retroactive ban. So air conditioners which were built before then would continue to operate, and frankly, they would continue to leak. So the stock, so to speak, of CFCs that had already been produced was mostly going to make its way into the atmosphere over time. But we knew we needed to stop adding more to the stock of products and then adding more to the atmosphere by the leakage from those products. And that was the plan. Now, we were able to get in 1987 an agreement to go halfway, a 50% phase out by I think it was by 2000. And that was where the developed countries were able to settle their differences. And I thought, you know, we've lost because we'll never get another shot at this. One of my, you know, close professional buddies in the EPA at the time who was running this program said, you're wrong, David, we'll be back at this in 3 years because the Antarctic ozone hole has just been confirmed to be caused by this. And the first agreement, everybody knew that NASA plane flight through the hole had happened, but the scientific community hadn't really processed the information yet. So there was going to be further reports that really nailed it, the ozone hole's connection to CFCs, and that would bring the parties back to assess whether the 50% over 15 years was enough. In fact, in 1990, the parties agreed in a meeting in London to accelerate that phase down to 100% over 10 years rather than 50% over a longer period. And in the US at the same time, we reached the agreement in 1990 on another set of amendments to the Clean Air Act. If I may, I might go back. Clean Air Act was adopted in 1970. It was amended in 77. It was amended again in 1990, and it basically, except for one other law passed in 2020 in this area, which we should talk about, basically hasn't been amended since. The legislative process, which started out incredibly bipartisan in 1970, still very bipartisan in 1977, went totally polarized by 1990, and it's gotten worse. But the 1990 Clean Air Act took this little section from 1977 that I described, 157, that gave some authority to EPA, and expanded it into a whole title of the Clean Air Act, Title VI, which at a minimum required EPA to do what it had agreed in the Montreal Protocol, which the Senate had given advice and consent. We ratified, so we were a party to it. At a minimum, you had to carry out the phase out, but Title VI also armed EPA with additional powers to go faster in a whole set of ways, dealing not just with the production of the chemicals, but with the way they're used and the way they're leaked. And so Title VI is itself, you could think of it as a very comprehensive statute all by itself.
Following up on that, and just to kind of set out some of the structure of Title VI, for our listeners, I know that you know all this, but so Title VI, it has a phase-out program for ozone-depleting substances. That's kind of its core. The substances are divided into Class 1, which are the most potent in terms of impact on the ozone layer, and then there's Class 2 substances, which also impact the ozone layer, but not quite as dramatically. And then, the title also has an imports and exports program that establish record keeping and reporting requirements so that we can track what's going on It establishes practices for the proper ways to destroy ozone depleting substances, because if you destroy them the wrong way, you cause different problems. It has programs for stationary refrigeration. It has programs for car air conditioners, for mobile source air conditioners. It has a halons program that halons are used in fire suppression, and fire suppression chemicals have a big impact on ozone. It bans the use of these ozone depleting substances for non-essential products. It's a very complicated program. Can you tell me a little bit about the development of the U.S. law and how that happened?
Right. Well, in the 1980s, NRDC worked with a number of states. Again, we didn't know when Congress was going to get around to amending the Clean Air Act. It was basically a decade-long campaign on many topics to get to those amendments. So we were working in this area with some states, and there were leadership states, California, Maryland, New York, a few others that wanted to go ahead with bans on non-essential products, with recycling requirements. One of the biggest sources of leakage back in the day was the car air conditioner. Now, because the auto manufacturers, because nobody had, until these problems arose, had any reason to really think about where the CFCs were leaking from and were going to, and they were cheap. Auto air conditioning systems were pretty leaky. They were built with hoses that leak, with fittings that weren't so robust. The whole engine is shaking all the time, vibrating. So it's, sort of challenging all the fittings. And the average car needed to be refilled with CFCs every 3 years. And the way you would do that would just be to go get a refill. You wouldn't even fix the leaks. Working with some folks at the EPA and they working with folks in the basically aftermarket parts and car repair business, they came up with a machine that so when you brought your car in for service because your air conditioner wasn't cooling right, most of the time it would not be empty of CFCs. It would still have a lot in there, but not enough to make the thing run right. And the first thing the technicians would do would be to open it up, empty out all the stuff that's in there, just let it go to the atmosphere, and then fix things maybe, or just fill it up again. And the industry came up with a machine that could be deployed in every repair shop that would suck out the remaining CFCs, and the automakers, under some pressure, agreed to honor their warranties if you reused the old stuff. And then you would only put in, you fix the leaks. You'd have to find and fix the leaks, and then you'd fill it up again with the old stuff plus whatever new stuff. And it was a huge success. Maryland adopted this. California was on the road to adopt. There was actually a ballot initiative in California called the Big Green, which included a whole series of restrictions on end uses of CFCs and so forth. And the industry, as I said, having dropped their position that this is all bogus and basically committing themselves to a transition, they said, well, we would really be better off with a federal uniform law than we would with all this popcorn going off at the state level. And we were able to negotiate with representatives of the industry agreement on most of these points, and we won some votes in areas where we couldn't get agreement. So we put together a consensus package on leaky car air conditioners and a consensus package on getting rid of silly strings and other non-essential uses of these chemicals, and a few other provisions. So that's sort of how it came together. And really since then, since the 1987 Montreal Protocol and the 1990 Clean Air Act, the attitude of the industry has been, as their chief lobbyist put it, it is better to be at the table than on the menu. And they have been willing to discuss, always, negotiate much of the time with us, and reach agreements with us and with other environmentalists and others who are pressing for transition to safer chemicals. So in addition to getting rid of the CFCs, the class 1 chemicals, a few years later, we reached agreement to get rid of the class 2 chemicals and a schedule for them. And that was adopted in amendments to the Montreal Protocol on a global basis. And this has continued. So there's really, we're in the fourth tranche of the phase out with the agreement in Kigali in 2016 to phase down the HFCs, hydrofluorocarbons, which were an interim but not perfect replacement for the CFC.
Could you speak more about the incentives provided to the industry to kind of help support this? Because this has been a program that has at least a reasonable amount of industry support, and at least part of that, I imagine, is the fact that, you know, as this program developed, they've earned kind of market rights in a way, the ability to use and produce and sell certain substances for certain amounts of time. Was that an important part of the back and forth discussion with industry?
Well, transition time is important. I mean, once you get, and this is true in many areas, once you get companies, polluters over the hump of acknowledging that they've got a problem and they need to do something about it, they say, well, we need some time and flexibility. So often we're able to combine ambitious pollution reductions or, you know, with some degree of implementation flexibility and time in order to get agreement. Now, you know, an industry like the oil industry is not yet convinced that they ever have to stop. But once you get enough pressure and enough public awareness and enough political pressure that an industry realizes something's going to happen here, we would be better off if we had some control over it, then you can get them into a space where you can, you know, trade ambitious reductions and some degree of time and flexibility to get it done. They also, as I mentioned, they realize that if the federal government isn't doing anything, states will step in. And they've wanted to preempt the states. They've basically been unable to get Congress to preempt the states, although there was in 1990 a short pause imposed on some states. And there is in the 2020 bill on HFCs, there is a short pause on state action in some areas. But that's the most they've been able to get in the way of preemption, because the states are jealous in guarding their prerogatives, as are we. And the threat still remains that if the phase down of HFCs should stall, that the states will step in again. So they get some degrees of market certainty or the ability to make plans. Now, this industry makes alternative chemicals that work, and then alternative chemicals tend to be under patent. The old ones tend to run out of their patent. So there is some financial advantage for the chemical producers to have a regime which requires them to replace the chemicals. What sort of restrains the power that they get out of that is that they don't know all the alternatives. For example, the entire electronics industry has learned how to make circuit boards without solvent cleaning. So they don't need to buy any chemicals, new or old, from those chemical companies anymore. American refrigerators now can be made with hydrocarbons as the refrigerant. And American supermarkets can use CO2 itself as the refrigerant. And so, you know, if the fluorocarbon companies want to introduce an alternative which is too expensive, or doesn't have enough, you know, performance attributes over these alternatives, it loses market share. And for them, the market for air conditioning and refrigeration is growing fast enough, especially outside this country, that they can, you know, make a good business with the alternatives, even though they're, from a point of view, if you looked at a big pie chart, a larger and larger fraction of the market for each of these products is being satisfied by other things. So they have a business case that works for them. And as a result, we have, it's not attention free, It's not a happy friendship, but it's a very good working relationship with the producers and users of these chemicals. And as I said, it allowed us to reach an agreement, first internationally and second domestically, on the phase down of the HFCs, the sort of the fourth round of the phase out.
So I think this naturally is a reasonable transition to talk about the Mexican case. This was a DC Circuit case where the DC Circuit held that Section 612 of the Clean Air Act doesn't require or give EPA the authority to require manufacturers to replace non-ozone depleting substances such as HCFCs. And so, as we talked about, the centerpiece of Title VI is a domestic phase out of substances that deplete stratospheric ozone. And those substances are replaced, and they're replaced through EPA promulgates rules that explain how those replacements can happen. And there's a key issue that's kind of developed, based on some of the regulations that were passed in 1994, I think. Is there a point at which chemicals should no longer be classified as substitutes? EPA said yes in the early 1990s, and that question was kind of teed up in the Mexican case. There, EPA was replacing substitutes that it determined posed a risk to human health and the environment with other substitutes that it thought were less potentially harmful to human health. And the DC Circuit said, no, EPA can't do that. I assume that's problematic from your perspective. I was wondering if you could explain why and give your perspectives on the case.
Yeah, well, when you cast your mind back to the late 1980s, early 1990, when we're working with members of Congress and with other interest groups to put the 1990 amendments together, you can imagine that, you can foresee some problems and you can't, and there's some that you just simply didn't foresee. Clearly, the 1990 amendments require EPA to add to the list of chemicals to be phased out anything that was later determined to hurt the ozone layer. And one such chemical was called methyl bromide. It was a pesticidal chemical, and EPA did add it, and it's almost completely phased out now. There wasn't any legal challenge to EPA's authority to add it to the list because the statute said you can do that. Well, what about a chemical that's dangerous in another way? And the only part of the Title VI that expressly deals with that is the section you mentioned, Section 612, called Safe Alternative Program, and it authorized EPA thought and we thought, to not only to stop the use of the lower ozone depleting chemicals when safer things were available, but also to eliminate a non-ozone depleting alternative, which was demonstrated to have some other adverse effect if there was a safer alternative still. And EPA, in the run-up to, let me go back one step. So the negotiations, international negotiations to phase down HFCs really started at the beginning of the Obama administration. I thought it would take 2 years. It took 8. And along the way, the US, with industry support, with environmentalist support, and a coalition of other countries was proposing a phase-down arrangement, as was ultimately adopted. The US wanted to show that it was in good faith, trying to walk the walk at home. And not having the authority to directly phase down the production of the chemicals, the EPA turned to the Safe Alternatives provision and said, we can, with appropriate lead time, ban the use of certain refrigerants, let's say, or foam blowing agents and so forth, because there are now, unlike in the early 90s, there's another tranche of alternatives, some of which are fluorocarbons, some of which are not, which are safe. And what is the problem with the HFCs? Well, they don't hurt the ozone layer because they don't have chlorine in them. But all the fluorocarbons, to varying degrees, are heat trapping greenhouse gases. The CFCs were the worst. Why? Because on any given day, they absorb a tremendous amount of heat, like thousands of times what CO2 does. And the CFCs lasted for 100 years or more in the atmosphere. So they were doing this every day of their residence in the atmosphere. The HCFCs and the HFCs have the same property of soaking up heat, but they don't last as long in the atmosphere. So their cumulative damage is much less because they decay out faster. And the current generation, things called HFOs, break down even faster, like in a few days or less than a year. So their potency as greenhouse gases goes down as their lifetime goes down. In 1994, when we were trying to replace CFCs, it seemed like a good idea at the time to switch to HFCs because they were lower on the ladder of greenhouse gas chemicals, but they didn't hurt the ozone layer. But in 1994, EPA says this is not forever. We're going to reevaluate this as time goes on. And as time went on, by the time of the Obama administration, the industry had come up with another set of alternatives with lower global warming potential. Some of them with none at all, or virtually none at all.
Just to repeat some of what you said for clarity. So it sounds like what we're dealing with in the Mexichem case then is an EPA rule. So the federal government passed a rule saying we're going to require different substitutes, the substitutes we were using before,
right,
even though they don't harm the ozone layer, they have these other side effects, these warming effects. And
they contribute to climate change.
Right.
And so here's where this opinion in Mexichem versus EPA came in. And there was an opinion by then Judge Kavanaugh, 2-1. There was a very vigorous dissent. Judge Kavanaugh issued a ruling, which, it's kind of hard to parse. He says, I'm not questioning these. EPA can put these chemicals on the bad list because they hurt the climate. That's okay. If anyone is still using an ozone-depleting chemical, EPA can say you can't replace that ozone-depleting chemical with anything on the bad list. That's okay. What EPA can't do, he said, was once someone has switched to the HFCs and basically is an incumbent user of the HFCs, they are no longer using an ozone-depleting chemical. So they cannot be made to replace the HFCs, even though they're on the bad list. Kind of doesn't make a lot of sense. But it blocked those rules. That led to, and we were unable to get the full court or the Supreme Court to revisit that, even though this case was brought on behalf of just 2 companies. Everybody else in the industry was copacetic with the EPA rules.
Yeah, I was going to follow up with that. One comment and then one question. The thing I wanted to highlight is it's interesting that this case was, even though it was a rule that was written in the Obama administration, it was defended in the Trump administration. So, interestingly, you had the Trump administration defending a rule that would take substances out of the air because of their climate change potential. And then the question is, you mentioned that industry supported your position on this, and I've read the briefs, they did. Can you tell us a little more about that dynamic?
Well, we had, so Mexichem is a Mexican-owned producer of the chemicals. They have a facility, I think, in Louisiana. And Arkema is a French-owned company with some U.S. facilities as well. The other smaller players, the bigger players in making the chemical are Honeywell and a company called Chemours, which is the spinoff of the DuPont operation. DuPont doesn't make these chemicals. DuPont's gone into, just changed its business, and they spun off the makers of the HFCs into a company called Chemours. So those 2 companies were interveners, as were we, all of us together defending the EPA rules. The decision, came as a surprise and something of a shock. The other judge was Janice Rogers Brown, and it was her last opinion before she retired. So our response was to go back to the playbook of working with the states. And over the next couple of years, from 2017, 18, 19, we worked with California, with most of the states that are, I guess you would call them the blue states that are active on climate change, and worked with them to adopt through state regs or state laws, as a matter of state law, to adopt the restrictions that EPA had put into those rules. The industry was desperately concerned that we would get the states to do lots of new things, or lots of things that were different one from another. And we told them, we're going to work on this hard at the state level unless there is a federal solution. The states tended to stick together in the sense of proposing and enacting regulations that basically just embodied the EPA rules that had been struck down at the state level. And by 2019 or so, we had covered about a third of the market. Companies don't like to have different requirements in different states, and when the environmental requirements, get adopted by a third of the market of the countries, states representing about a third of the market, you see a kind of tipping point in the sort of controls, practically speaking, what they market in the rest of the country, because they don't want to have two product lines and so on. But they wanted to eliminate this uncertainty. And so we found that all the companies, even Mexichem and Arkema, were interested in negotiating on a new federal law. And we worked with them and with consultants to them to draft something up that was modeled on Title VI. Basically, you could think of it as an amendment to Title VI, although it has its own name, the American Innovation and Manufacturing Act. And it was touted and enacted as an independent law, but it does have cross references to the Clean Air Act in it. And it happens to be codified right behind Title VI. And it will work seamlessly as a part of Title, call it 6.1. It restores the authority to force the replacement of HFCs when safer alternatives are available. So it, not in so many words, but in a section of the new law, overrides the Mexichem decision. And it provides the EPA with the requirement to phase down the HFCs on at least the same pace as the Kigali Agreement, which had been reached several years before. So the US is now implementing the phase down of HFCs. And I think there were 15 petitions to EPA, because there's a petition process provided, including a whole number by industries and by states, not just us, to adopt versions of and extensions of the use limits and replacement requirements that EPA had started with in 2015 and 16. And EPA has granted those petitions and is in the middle of a 2-year rulemaking to carry out those substitutions in areas like air conditioning and refrigeration, other major uses. So if you can phase down the production and knock out uses at the end use level where there are satisfactory alternatives already available, and also one other thing, we can control leakage and recover as much of the chemical that otherwise would leak, clean it up and reuse it, then you can meet the Kigali phase down schedule with no sweat and maybe go faster. And the law allows, as Title VI did, the new law allows for EPA by rule to accelerate the phase down of the HFCs over time. Just as countries will consider in future years whether you can speed up the general phase down globally under Kigali. So, we've seen this movie, we know how it works, we know how it ends, and it is to change the metaphors, it's a playbook that works. How important is all this? Well, getting rid of the CFCs and the other ozone-depleting chemicals has saved millions of lives, will save millions of lives that would have been lost over the coming years, coming decades, if we had not done that. But perhaps even more important is that CFCs were incredibly powerful greenhouse gases. And one way to think about it is if we had not eliminated the CFCs, then the warming we are feeling now, we would have felt 10 years ago. And it would be even worse now. That's how important it is. It's at least a 10-year slowdown of the march of climate change to have got rid of those chemicals. And it is forecast that if we had let the HFCs keep growing, because as I mentioned, in much of the developing world, they're just getting air conditioning and refrigeration now, and those markets are just rocketing. If we let the HFC serve that market, then we would see another up to a half a degree of warming by 2100. And who needs an extra half degree of warming if you're trying to hold the overall warming below 2 or 1.5 degrees? So this is enormously important in fighting climate change, even though the first objective was to save the ozone layer, which was important enough on its own.
And just to wrap this up, one final question for you is, we started by mentioning this is commonly viewed as one of the most successful air programs that we've ever put into place. What's your status report on how the ozone layer is doing now? I know it's not perfect, but it's better.
Right. The ozone layer is recovering. The levels of the CFCs and the other bad chemicals measured in the atmosphere continues to go down. The level of there is a depletion, not just at the when the Antarctic ozone hole reappears every springtime, but there is a depletion over the latitudes where we live. It's quite small, and it would have been growing. It would have been very large. There is a video, a YouTube, which you might want to link to, a guy named Paul Newman, who's a NASA scientist. He's done something called The World Avoided, and it is a side-by-side modeling of what the ozone layer would have been like had we done nothing versus the way it looks like it's going under the Montreal Protocol. And these are where you get the estimates of the tremendous millions of lives saved, cataracts not caused. There may be immune diseases which are triggered by UV radiation that we will avoid. Tremendous destruction of plant life by UV radiation, including crops and forests. There was a recent study that showed that the ability of forests to uptake carbon would have been severely harmed by the damage the UV radiation would have done to the leaves of the plants. So that indirectly, the CFCs, in addition to hurting us by soaking up the radiation directly, would have enhanced climate change by damaging the ability of nature to soak up carbon dioxide from the atmosphere. So in so many ways, we avoided disaster. And let me put it this way, a disaster on top of the catastrophe that is climate change. So, and it should be a lesson for how we can back our way out of climate change. You have to phase down the reliance on fossil fuels. You have to replace them with clean energy, and we're not doing that nearly fast enough. This area of policy is a victim of two things: the incredibly greedy digging in of fossil fuel interests and the polarization of our politics that they and others have caused, so that instead of passing Clean Air Acts and Clean Air Act amendments by overwhelming majorities, you can't get them past the post. Now, we got the AIM Act of 2020 through by working with industry and building up in the Senate in particular, like a Noah's Ark approach, one Democrat, one Republican. And we started with, I think, 6 co-sponsors on each side. And it went up to 17 on each side. And at that point, there was enough support that you could get this major piece of legislation included in the omnibus bill that President Trump, you may remember, reluctantly finally signed in late December or January of 2020. But it's the most important piece of new climate legislation that is passed in a long time. We rely on the existing Clean Air Act to curb carbon dioxide, to curb methane, other things. The Supreme Court is hearing a case. We're waiting for a decision in West Virginia versus EPA, which will tell us a lot about whether the court will cripple the existing authority or allow EPA to proceed. But that's where we are.
Well, I appreciate you joining me today. We're at the end of our appointed hour, but I just wanted to take a little time to thank you for telling me your story, and thank you for your career. I mean, you've done a lot of fascinating things over a long time in an era when environmental laws changed dramatically, and you've made a big difference. So I just wanted to tell you that, and thank you.
Thanks for having me.
Thank you for joining me.
We hope you enjoyed today's episode. To learn more about our section, Please visit our website at www.americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.